Good morning, students. Say your prayer. Thank you. நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்ல ஆசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்து முறையாக அன்போடு கல்வியை போதிப்பேன். Okay, students. So take your social science book and take page number 255. So today we will discuss about judiciary. So the third organ of the government. So previously we have discussed the two organs. So how many organs are there? Yeah, the three organs. Yeah, so legislative, executive, then judiciary. So we have discussed legislative and executive in our previous classes. So today's class we will discuss about judiciary. So judiciary is the third organ of the government, so which plays an important role in protecting the rights and freedom of the citizen. Yeah, so judiciary, an important organ which play an important role in protecting the rights and freedom of the citizen. Okay, ma? So in our previous class we have discussed about the legislative organ of the central government, that is the parliament. Yeah, so what are the two houses? So name the two houses of the parliament. Yeah, Rajya Sabha, then Lok Sabha. So how was Rajya Sabha otherwise called as? Yeah, Council of States. Then Lok Sabha, yeah, House of the People. Then first Rajya Sabha. So how many members are there in Rajya Sabha? Yeah, there are 250 members. Yeah, so Rajya Sabha. So the term of office is, so it is not subject to dissolution as like that of Rajya Sabha. So generally the term of office of Rajya Sabha is 6 years. Yeah. Then we discussed about the qualification. So must be a citizen of India. So must have completed 30 years of age. So economically solvent. So like this. So we have discussed. Then election. Yeah. So how were the Rajya Sabha members elected? Yeah. So the members were indirectly elected. So they were indirectly elected by the people of India. So how were they elected? Yeah. They were elected by our elected representatives. That is the state legislative assembly members only elect the Rajya Sabha members. Yeah. Then Lok Sabha. Yeah. So how many members are there? Yeah, 545. Yeah. So how many of them were elected directly by the people of India? Yeah, among 545, 543 were directly elected. Then what about the remaining two? Yeah, so they were Anglo-Indian community members nominated by the President of India. Yeah. Then the term of office is 5 years. Yeah, so before, so if suppose the ruling party loses its majority means, then the term of office is not 5 years. So it can be dissolved before the term. Yeah, so or if the Prime Minister wish means, then request the President means, then the President passed the resolution. Yeah, so order for the dissolve of Lok Sabha. Yeah, then election. So based on the universal adult franchise, so the people of India, so those who have completed 18 years of age, so choose their representatives. Yeah, so India was divided into so constituencies, so which have equal population. Yeah, so all the constituencies have equal population. Yeah, so the members were chosen by the people of India. Then we discussed about the speaker. Yeah, so the Lok Sabha was presided over by the speaker. Then we have discussed about the powers and functions of the parliament. Yeah, so all the bills can be passed in the parliament only. Yeah, so in this case we have some difference. Yeah, that is Lok Sabha have more power in Rajya Sabha in some event. Yeah, so say for example money bill. So we have discussed about the money bill also. Yeah, so money bill can be introduced only in Lok Sabha, not in Rajya Sabha. So there is no power for Rajya Sabha in case of money bill. Yeah. Then remaining ordinary bills can be introduced in Lok Sabha or else in Rajya Sabha. So we have discussed these factors. Then finally the Attorney General of India. So he is the highest law officer of the country. Yeah, so he was appointed by the President and he can be removed by the President only. Yeah, so he is in charge to attend the cases against the government of India. So he argue for the support of the government. So he can present anywhere. That is, he can argue in any court in India. So he can argue in any court in all over India. So not in India. So he can argue in any court of India. Then so we have discussed these things. And Attorney General. So he has the power to participate in Lok Sabha and Rajya Sabha meetings. But he has no right to vote. So he can present in the meeting, but he have no right to vote in Lok Sabha or Rajya Sabha. So these are the things so which we have discussed in our previous class. So today's class we will discuss about the judiciary, so the third organ of the government. So the Supreme Court is the guardian of the constitution. So guardian means a person or an institution that guards or protects something. So Supreme Court, so they protect the constitution. So that's why Supreme Court is the guardian of the constitution. Our judiciary is autonomous, that is they have judiciary have its own power, so autonomous of legislative and executive wing of the union and state government. So judiciary is independent of legislative and executive wing. So if you take legislative and executive, so they are mostly interdependent. That means, so legislative, so the law making body, so the government only can make laws, then they only can execute it. So almost they are interact. But judiciary, they are independent. So judiciary is autonomous of the legislative and executive wing of the both union and state government. And integrated judiciary means a single judicial hierarchy for the whole country. So here we can say India have integrated judiciary. So that means there is a single judicial hierarchy for the whole country. So for the whole country there is only one Supreme Court. Then the judiciary plays an important role in defending the rights and freedom of the citizens. So defensive means that protects. So the judiciary play an important role in protecting the rights and freedom of the citizens, and also it plays an important role in analyzing and interpreting the necessities of laws and the constitution. So apart from protecting the rights and freedom of the citizens, it play an important role in analyzing and interpreting. So interpreting means explaining and understanding the meaning of something. So they only explain the need of law, they only analyze and explains the need of laws and the importance of constitution. So apart from protecting the rights and freedom of the citizens, so they also explains, so they also tell us the importance of the laws and also the importance of the constitution. So Supreme Court is the guardian of the constitution. So they are independent from legislative and executive wing. So there is only one Supreme Court. So there is a single judicial hierarchy for the whole country. Okay. So where is Supreme Court of India so located? It was in New Delhi. So the Supreme Court of India was at New Delhi, which was inaugurated on January 28, 1950. So it succeeded the Federal Court of India, established under the Government of India Act 1935. So after we became Republic, so Supreme Court of India so became the highest court in India. So Supreme Court became the superior of all the court. So at the commencement of the constitution, that is commencement means so beginning of something. So at the beginning of the constitution in 1950, our Supreme Court consists of 8 judges including the Chief Justice. Initially at the time of Republic, so in the year 1950, so Supreme Court consists of 8 judges including Chief Justice. At present, the Supreme Court consists of 34 judges including the Chief Justice. So because of the increase in population, so the number of judges was increased. So initially only 8 judges including Chief Justice. Now there are 34 judges including the Chief Justice. Appointment of the judges. So how was the Chief Justice and other judges appointed? So who appointed? So the Chief Justice of Supreme Court is in India is appointed by the President of India. So the Chief Justice of Supreme Court in India is appointed by the President of India. Then the other judges are appointed by the President in consultation with the collegium with the Chief Justice head. The Chief Justice of Supreme Court in India is appointed by the President. So the other judges so were appointed by the President in consultation with the collegium. So collegium means an advisory or administrative board. So there is an advisory board, so with the Chief Justice as its head. So based on their advice, so the other judges were appointed by the President. So however the 34 judges were appointed, so the Chief Justice was appointed by the President of India, and the other judges were appointed by the President in consultation with an advisory body. So with the Chief Justice as its head. So qualification. So what are the qualifications to become a Supreme Court judge? So first, he must be a citizen of India. So he must be a citizen of India. Then he should have worked as a judge of a high court at least 5 years. So must be a citizen of India. then he should have worked as a judge of a high court for at least 5 years. Then he should have worked as an advocate of high court for at least 10 years. So judge 5 years, then advocate 10 years. So here it takes 15 years. So he should be in a high court for 15 years. Then he is, in the opinion of the president, a distinguished jurist. So jurist means an expert in law. So in the opinion of the president, so he should be expert in law. So to become a judge of the Supreme Court, so the qualifications needed were, so first he must be a citizen of India. Then he should have worked as a judge of high court for at least 5 years. Then he should have worked as an advocate of high court for at least 10 years. Then he is, in the opinion of the president, a distinguished jurist, that is an person expert in law. So apart from this, the constitution also provides for the appointment of judges to the Supreme Court and ad hoc, that is temporary basis. So apart from this, so the Constitution of India so provides for the appointment of judges to the Supreme Court on temporary basis. So the Chief Justice and other judges of the Supreme Court hold to office up to the age of 65 years. So the Chief Justice and other judges of the Supreme Court hold to office up to the age of 65 years. So the Constitution so provide for the appointment of judges to the Supreme Court on temporary basis. So why temporary basis? Suppose if some of the judges or even Chief Justice unable to perform his duty, so for example, if he is sick, or if he is outside, means then the president can appoint a person as temporary Chief Justice or a temporary judge. So this Constitution provides such power to the president. So the term of office. So the term of office is not mentioned, but the maximum age is 65 years. So the judges of the Supreme Court can resign before their term by giving their resignation in writing to the president. So the judges of the Supreme Court can resign before their term. That is before completing 65 years. So before they attain 65 years of age, they can submit their resignation to the president. And also the parliament. So the parliament has power to remove the judges by invoking impeachment provisions. So impeachment means removing the higher officials. So this can be possible only with a special majority. So the parliament also has power to remove the judges by invoking impeachment provisions. So the Supreme Court has its permanent seat in New Delhi. So its seat was in New Delhi, but the Supreme Court has power to sit in any place. So not only in New Delhi. So Supreme Court can conduct a case wherever the court wish. So in the territory of India, wherever the court wish, so the Supreme Court can conduct the case. So it may also sit any other place in India, which may be decided by the Chief Justice of India with the approval of the President of India. So the Supreme Court may also sit any other place in India. So apart from New Delhi, so the Supreme Court may also sit in any place in India which may be decided by the Chief Justice of India. So the place must be decided by the Chief Justice of India with the approval of the President of India. Yes, with the approval of the President of India. So the Constitution so provides for the appointment of judges to the Supreme Court on temporary basis. So ad hoc means so temporary. So the Chief Justice and other judges of the Supreme Court hold the office up to the age of 65 years. So the maximum age is 65 years. Then the judges of the Supreme Court can resign before their term by giving their resignation in writing to the President. So they can submit their resignation in a letter, so in writing form to the President. Also, the Parliament has the power to remove the judges by invoking impeachment. So invoke means the appeal to somebody as an authority for an action or in support of an argument. So that is appeal to somebody. So they promote impeachment. So they appeal for impeachment. So the Parliament can remove the judges by introducing impeachment provisions. So the Supreme Court has its permanent seat in New Delhi. So already we saw that was inaugurated. So Supreme Court of India was in New Delhi, was inaugurated on January 28, 1950. So it may also sit in any other place in India which may be decided by the Chief Justice of India with the approval of the President of India. So the Chief Justice can decide the place, but he or she should get the approval of the President of India. So powers and functions of the Supreme Court. So we have discussed about the Supreme Court, so the guardian of the Indian Constitution, then the composition. So how many judges are there, including the Chief Justice? Yeah, 34. So who appoint the judges and the Chief Justice? Yeah, the President of India. Then we discussed about the qualification. So must be a citizen of India. Then worked as a judges of a High Court for at least 5 years. Then worked as an advocate of High Court for 10 years. Then in the opinion of the President, he must be a distinguished jurist. Yeah, then the maximum age is up to 65 years. Yeah, and then so the Supreme Court has its permanent seat in New Delhi. Then the powers and functions of the Supreme Court. So the Supreme Court, so it is an independent organ. So already we discussed, so judiciary is the third organ of the government. So legislative, executive. Then judiciary, so they have their own power and function. So they can be studied under the headings: original jurisdiction, appellate jurisdiction, advisory jurisdiction, miscellaneous jurisdiction, then judicial review. So jurisdiction means the authority that an official organization has to make legal decision about somebody or something. So jurisdiction means the authority that an official organization has to make legal decisions about somebody or something. The authority that an official organization has to make legal decisions. So Supreme Court, so it is an official organization, so which can make legal decisions about something or somebody. So they only make legal decision. First, original jurisdiction. So the cases which are brought directly in the first instance to the Supreme Court come under the original jurisdiction. So the cases which are brought directly to the Supreme Court. So not all the cases are brought directly to the Supreme Court. So only some of the cases are brought directly to the Supreme Court. So what are the cases that were brought in first instance directly to the Supreme Court? Dispute between the government of India and one or more state. So dispute between the central government and state government. So dispute between two or more state. The writs issued by the Supreme Court for the enforcement of the fundamental rights. So what is the writ? Right to constitutional remedies. So we have learned in first lesson now. The habeas corpus, mandamus, certiorari, like that. So the writs, so issued by the Supreme Court for the enforcement of the fundamental rights. So the Supreme Court has the power to issue writs. So if the person, so if an Indian citizen, so didn't get or unable to enjoy any fundamental rights means, then he can go for Supreme Court. So for Supreme Court, so already we saw, so guardian of the Constitution. So in these cases only, so the case Supreme Court can directly involve. So the cases which are brought directly in the first instance to the Supreme Court come under the original jurisdiction. So this may be dispute between the government of India and one or more state, dispute between two or more state, then the writs issued by the Supreme Court for the enforcement of the fundamental rights. So that's why we can say Supreme Court is the guardian of the Constitution. So so if there is any problem between two family or between two village means, then there is district court. If there is problem between two district means, then there is High Court. Then if there is problem between two state or more state means, there is Supreme Court. So Supreme Court is the highest court of appeal. So that is the original jurisdiction. So some of the cases are brought directly to Supreme Court. Appellate jurisdiction. So appellate means a court in which people can appeal against decision made in other court of law. So appellate jurisdiction. So appellate means a court in which people can appeal against decision made in other court of law. That means if the people not satisfied with the decisions of the lower court, that is High Court or District Court means, then they can go for appeal in Supreme Court. So the Supreme Court is the final appellate court in the country. As regard the appellate jurisdiction, the Supreme Court here appeals against the decision of the High Court in civil, criminal and constitutional cases with a certificate from the High Court that it is fit to appeal in the Supreme Court. So as regard the appellate jurisdiction, the Supreme Court can hear appeals against the decision of the High Court in case of civil, criminal and constitutional cases with a certificate from the High Court. That is, the High Court have to give the certificate that this can cases is fit to appeal in the Supreme Court. So such a case can be brought before the Supreme Court only if the High Court certifies that the case invites a substantial law as to interpretation of the Constitution. So such a case can be brought to the Supreme Court only if the High Court certifies that the case, so that is the case invites a substantial of law. Substantial means enforcement of law. So if the Supreme Court wants to hear a case means the High Court certifies that the case invites a substantial of law as to the interpretation of the Constitution. So then only the Supreme Court can take the case. So the Supreme Court is the final appellate court in the country. So as they record the appellate jurisdiction, the Supreme Court hears appeals against the decision of High Court in case of civil, criminal and constitutional with a certificate from the High Court that it is fit to appeal in the Supreme Court. Then advisory jurisdiction, so advice body. So the Constitution confers on the President the power to refer the Supreme Court any question of law or fact which in his opinion is of public importance. So if the President have any doubt so in the public matter means then he refers to the Supreme Court. So the Constitution confers on the President the power to refer the Supreme Court any question of law or fact which in his opinion is of public importance. So if there is any public matter arises means the President can refer to the Supreme Court. So about the question of law, so Supreme Court can advise the President. So but it was on the President. So it was President wish to accept or omit the advice. But it was the duty of Supreme Court to clear the doubt. So about the public importance, about the question of law in case of public importance, so which was asked by the President. Then miscellaneous jurisdiction. So miscellaneous means consisting of many different types of things. Miscellaneous means consisting of many different types of things. So the law declared by Supreme Court is binding on all court within the territory of India. So the law declared by the Supreme Court is binding on all court within the territory of India. So the law declared by High Court, it is applicable only to the respective state only. But the law declared by Supreme Court is binding on all court within the territory of India. Then the Supreme Court is authorized to make rules for regulating generally the practice and procedure of the court with the approval of the President. So the Supreme Court, so they have the power to make the rules and regulations. So generally for the practice and procedure of the court. So how to behave in court. So what are the rules and regulations. So how a lawyer, how an advocate, how a judge should behave. So what are the procedures should be followed. So they can be authorized, these things can be authorized by the Supreme Court with the approval of the President. So in case of miscellaneous jurisdiction, the law declared by the Supreme Court is binding on all court within the territory of India. Then the Supreme Court is authorized to make rules for regulating generally the practice and procedure for the court with the approval of the President. Judicial review. So judicial review means a procedure by which a court can review an administrative action by a public body and secure a declaration, order or award. A procedure by which a court can review an administrative action by a public body. So the power of the judicial organ to declare a law as unconstitutional is known as judicial review. So the power of the judiciary to declare a law as unconstitutional is known as judicial review. So the Supreme Court enjoys this power. So only the Supreme Court can declare a law as unconstitutional. So the Supreme Court of India has individual review power with regard to dispute between the center and the state. So dispute between the center and the state to interpret and clarify a provision of the Constitution about which there are some doubts and difference of opinion. So to interpret and clarify an article so which have doubt and have people have different opinion, then protecting the fundamental rights. So the Supreme Court has the power to declare a law unconstitutional. So when the court can declare a law unconstitutional, suppose there is a case between center and the state, then the court can declare a particular law as unconstitutional. Then the Supreme Court can interpret and clarify a provision, clarify an article of the Constitution, so which have doubt and different of opinion, then protecting the fundamental rights. If any law so that affects the fundamental right means, then the Supreme Court can declare that the particular law is unconstitutional. Then those laws passed by the legislature which are not in accordance with the Constitution. So the legislative, that is the Parliament or the State Assembly, pass any law means which can affect the fundamental right means, then the Supreme Court can declare that the particular law is unconstitutional, that is against Constitution. So these are the powers of Supreme Court. So judicial review. Okay students, so today we have discussed about Supreme Court. So Supreme Court is the guardian of the Constitution. So the composition, then appointment, the qualification. So powers and functions. So what are the powers and functions of the Supreme Court? So what are the headings? You can read. Original jurisdiction, appellate jurisdiction, advisory jurisdiction, miscellaneous, then judicial review. So under this heading, so we have discussed about the powers and functions. So Supreme Court is the highest court of appeal. So they was guardian of the Constitution. So Supreme Court is considered as the guardian of the Constitution. So they have the power to declare a law unconstitutional. So it was called as, this power was called as judicial review. So if there is any dispute between central and state government or between two or more state means, then the jurisdiction is called as original jurisdiction. So these things, so we have discussed it in this class. So if you have any doubt in this class means, so please contact me. So take your textbook, take page number 255. Textbook reading. Read that qualification of Supreme Court judges. So read that 4 point, then that paragraph also. So fully you have to read. Then homework. So take page number 258. Sixth Roman letter. Answer in detail. So already you have completed first, third, then fourth. So second detail. Explain any three jurisdiction of the Supreme Court of India. So take page number 255, 256. So they ask any three heading only. Original jurisdiction, appellate jurisdiction, advisory jurisdiction, miscellaneous jurisdiction, then judicial review. So in this 5 heading, you choose any 3 heading. It's your choice. So any 3 heading. And write it and read it well. So I think you have read 4 detail in this lesson. So take care of your writing work. So do it properly and regularly. So thank you. Have a nice day. Okay students, so in this class we have discussed about the union government. So the 3 organs. So executive. So in executive we discuss about the president, then vice president, the prime minister and council of ministers. Then in legislative, so we have discussed about the 2 houses of parliament. So Lok Sabha, then Rajya Sabha. Then the speaker and attorney general. Finally, we discussed about the judiciary. So the 3 important organs of union government. So they have to work together. So to protect the citizens of India, so they are working very hard. So these are the 3 important organs of the central government. So if you have any doubt in this lesson, so please do contact me. So this is a very important lesson. So for your future also, and also for 10th. So these lessons. So if you want to develop the political knowledge, so you have to develop your political skill. So you have to regularly watch the news. So there is change often in case of executive, legislative, judiciary. You have to watch the news. So to know more about these organs. Okay students. So once again, thank you. So do your homework.